Hi, this is Brian Ka with another video to help you pass the California baby bar and the bar exam. So we're going to do another remedies question, and this is from question 5 from July 2023. So before we start, as usual, we're going to look at the call of the question and figure out before reading the facts what they want us to focus on. So number one says, what equitable remedies does Steve have against Barbara? Discuss. Okay, so Steve versus Barbara. I personally love these types of questions because when they tell you what equitable remedies, there's only so many that you can discuss. For example, it's either going to be TRO, preliminary injunction, permanent injunction, and specific performance. Now, there are other equitable remedies which are not very common. I think I saw this maybe like once in like um, in the last like 10 essays for remedies, which is ejectment and replevin. Another two that could be discussed are constructive trust, equitable lien. So these should be like second nature to you by now. We've done so many. I've done so many of these, over and over and over again. That now, these come out automatically. And for you to succeed in remedies essays, these have to be second nature. I cannot stress that enough. And it's not that hard if you just keep doing them, and you're basically learning another language. And the thing that I was thinking about today while I was walking my dogs is that the law, to me, even though it took so many years to just get through law school, it's not testing you on intelligence. Many people are mistaken because only smart people do law school and they become lawyers. That may be true to a some degree, but after repeating law school for so many years, I realized that law school is more about practice and doing things the correct way over and over and over and over again until you master it. At first, when you try to master a language, let's say I want to learn Japanese and I don't know any Japanese, it's not going to be easy. But if you keep doing it over and over again, it eventually becomes second nature to you. And I think that's the perfect analogy for law school, or in fact, taking the bar exam. It's not necessarily whether you're so smart, you're so intelligent. It's more about learning how to repeat the pattern and repeat the things that were given to you, in the past, in the previous exams. So with that in mind, these are the things that you're going to have to think about for question number one. Now, for two, it says, what equitable remedies does Acme have against Barbara, right? Acme versus Barbara. again, we're not going to get away from this roadmap. It's again asking for equitable remedies, and it's going to be either one of these, two of these, or three of these, depending on what the facts are asking us. So it's not going to be too difficult as long as you have these memorized and the elements required for each of these memorized in your head. Because obviously you should know by now how to analyze using facts and plugging them in to these rules. Now, number three is a little different. It's asking what money, if any, can Acme recover as part of an equitable remedy from Barbara's checking account? Again, it's a very specific question. What money can be recovered from Barbara? Okay, so that's the question. And let's see what we get from reading the facts. So Steve owned the property in the state of Columbia that Barbara offered to buy for $500,000. Okay, so Steve is the owner of the property, and Barbara is the one that wants to buy for $500,000. Steve agreed to sell provided that he retained the mineral rights and had access to the land. Okay, so this was the price. Steve agrees to sell, but there are conditions. Number one is retaining mineral rights, right? And number two, access to the land, right? There are two conditions, and that's the way that Steve wants to sell his land. So Barbara later accepted Steve's conditions and said that she would tell her attorney to prepare the necessary papers. So they agreed. She told Steve that she was going to tell her attorney to drop a contract which includes these two conditions. Okay. When Steve met with Barbara to sign the papers, he asked if the documents included his conditions, and she assured him that they did. In fact, Barbara had not told her attorney of Steve's conditions, and they were not in the papers that he and Barbara signed. So right away, um, it looks like there may be an issue with fraud or misrepresentation, right? Fraud, misrepresentation, and possibly uh, mistake. But since it's one party was aware of the mistake, Barbara, this is usually probably going to be a unilateral mistake because she had reason to know of the mistake, right? Okay, so shortly after the sale, Steve decided to investigate whether his former property had any mineral deposits. Barbara refused to let Steve and his geologist on the property and erected barricades to prevent their access. It was then that Steve realized that the documents he signed omitted his conditions. Okay, so they agreed to include these two um, conditions, but he was basically kicked out and was not let in. So right away, that should trigger um, for number one, we're gonna have to talk about things like TRO, preliminary injunction, possibly permanent injunction. and specific performance. And I hope you understand why we have to discuss them. It's because they had an agreement so that he could have access to the land. But once he was denied the access, you have to ask the court for remedies. But in this case, rather than legal remedies, which is money damages, you want to ask the court to stop her from blocking the road through specific performance and use TRO injunction, both preliminary and permanent injunction, to stop her from retaining mineral rights or selling the mineral rights to another third party. Okay. So Barbara had purchased Steve's property in cash, which included $250,000 of funds that she had embezzled from her employer, Acme. So we have number two introducing a new party. Um, Acme and Barbara embezzled 250,000 from Acme, and let's see. Barbara embezzled 250,000. Barbara later embezzled another 20,000 from Acme. Okay. Okay. So she embezzled 250,000 of funds, and then later embezzles $20,000 more. But what happens here is that she deposited in her checking account uh, containing 5,000 at the time. Okay, so she purchased 250,000, right? Later gets 20,000, but she had 5,000 of her own money, right? So here, because 250,000 was spent on purchasing the property, but later because she embezzled 20,000 on top of 5,000 that she had already in her bank, that left her at $25,000 in her bank account, right? Now, the following month, she paid off $25,000, right, of her outstanding debts, bringing her checking account balance to zero. So this kind of clears it up. She didn't have 250,000 in her bank account that was spent. Otherwise, she wouldn't have zero in her account. She would have 250,000. But because they're telling you that her account became zero, it means that this money was already spent. She was left with 20,000 plus 5,000. And then she spent 25,000, which means she was left with zero. And this is probably talking about the money that can be recovered from Barbara, because there's a rule called lowest intermediate balance rule, right? Which is basically saying that the money she had, when she spends it, it's assumed that her own money is spent first. And in this case, because she was left with zero, it means even though her money is assumed, it is assumed that her money is spent first because there's zero after spending 25,000 under lowest intermediate balance rule. It means that she's not going to be Acme won't be able to recover from her checking account, unfortunately, right? And that's what number three is asking for. So we have a basic outline. When you talk about Acme versus Barbara, what Acme wants to probably do is to hold the property under constructive trust and under equitable lien. So those are the two things that number two is trying to get us to analyze, right? Now, for constructive trust, it's usually the defendant is holding the property uh, as a trustee, and Acme or the plaintiff can tracing is allowed, trace the property that she holds now at $500,000. The money that was spent, 250 plus 20,000, will be traced to that $500,000 property. And if that value goes up, then uh, Acme will be entitled to getting that increase also. So if that increase from 250,000 and another $20,000, if that was contributed to uh, purchasing the property, but I think that they're only referring to 250 because this is, I guess, separate 25,000. So if the money that was embezzled was 250,000, then when it became $500,000, the value of increase, Acme can take that value of increase, right? Now, if it, uh, let's say, assuming that the property went down to like $100,000, in that case, um, Acme will suffer from choosing constructive trust because they're not going to be able to uh, ask for a deficiency judgment, but rather if the property goes down, they're going to be stuck with that decrease in value of that property. Whereas for equitable lien, that's more of a possessory interest, and the court is going to say, uh, you know, saying that Acme has a possessory interest and for sale, if possible, so that Acme can recover. Now, for equitable lien, if the property value goes up or down, Acme won't be affected. That's the big difference between equitable lien and constructive trust. And in that case, if there is, let's say, a decrease in value from 500,000 to, let's say, 100,000, uh, under equitable lien, they can pursue a deficiency judgment, and also, just like constructive trust, they'll be able to trace the money to the property also. So number two, I believe, is basically just talking about constructive trust, equitable lien, because Acme, Barbara embezzled 250,000 from Acme for the house and 20,000 whatever here. Um, they want you to talk about both constructive trust and equitable lien and plug in the facts and say that, conclude whether those equitable remedies will work in this case. Now, going back to number one, TRO, obviously, you're going to have to talk about things like irreparable harm, um, balance of hardships, plaintiff likely to prevail, and no defenses, no notice required, ex parte. And the main thing is to preserve the status quo. I think that's the trigger word. So I would always write that. The, the thing about TRO and preliminary injunction, what are different, uh, is that for preliminary injunction, you're gonna have to have notice, no ex parte allowed, but other elements are the same. Now, permanent injunction, you're gonna have to also talk about irreparable harm, that there is inadequate legal damages. That's a big one. And similar to specific performance, we're going to have to talk about feasibility, mutuality, and no defenses, right? And preliminary injunction and TRO, permanent injunction, will be used to stop Barbara from uh, retaining mineral rights or selling off the mineral rights to a third party. The main thing would be specific performance, asking the court to force Barbara to honor the contract. And for specific performance, as we've done so many times, you have to have a valid contract. You have to have certain definite terms, feasibility, mutuality, right? And inadequate legal damages and no defenses, right? So you're going to go through that for specific performance. It's going to be probably like 2 pages to maybe 2.5 pages. So you do that, discuss all of it, make sure to plug in the facts. And at last, because we have to talk about defenses, I would always, for remedies, talk about two things, and that are number one, latches, and number two, unclean hands, right? Unreasonable delay, which prejudices the defendant, right? Unclean hands, plaintiff is also at fault. So those two things should always be discussed. And lastly, we've already discussed this, but number three, it's asking if the plaintiff can recover from this checking account. And because of the lowest intermediate balance rule, it's assumed that the defendant's money is spent first, but because the defendant's money became zero after having 25,000 and spending 25,000, unfortunately, under the lowest intermediate balance rule, the plaintiff, Acme, will not be able to recover using this method, right? But they have rights in pursuing constructive trust and equitable lien, right? Because that's the best remedy that Acme can sue under. And here, these are the best remedies that Steve can pursue. And three wasn't really asking for what remedies, but rather they're testing you on whether you knew or you know about the lowest intermediate balance rule, which is a little bit confusing, at first. But if you just keep practicing and if you keep, you know, trying to figure out what that really is, look up on different things, do more questions, read, other horn books if you can, until you actually understand. Because for me, it took a while for me to even understand this, but after a while, it got better. and I was able to understand it better. And I believe with that, um, that should be enough for July 2023 question 5. Again, I hope this video was helpful to you. And we have, I believe, 2 more questions that we can do. And other than that, we've done every single remedies question that was ever administered by the State Bar of California. So I think that if you review all these videos that I've recorded, and if you feel a little bit, if you don't feel confident about remedies, I suggest that you watch the videos, try to understand each concept, make sure to memorize it, and I think analysis will come a lot easier. And with that, I thank you for watching another video, and I'll see you guys next time.